This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to explain why and how the state of California killed the so-called third-party tort of bad faith, and why the California Supreme Court eventually reversed its decision in a case called Royal Globe versus Superior Court, a 1979 decision that allowed an individual injured through the negligence of an insured to sue the insured's insurer for unfair claims practices pursuant to California Insurance Code Section 790.03, subdivisions H. 5. The Fair Claims Settlement Practices Act. The Supreme Court established a private cause of action to anyone who believed the statute was violated by the case called Royal Globe. It's held, quote, if, as we conclude, the act affords a private party, including a third-party claimant, a right to sue an insurer for violating subdivision H, it is inconceivable that the Legislature intended that such a litigant would be required to show that the insurer committed the acts prohibited by that provision, quote, subquote, with such frequency as to indicate a general business practice, close subquote. There would be no rational reason why an insured or a third-party claimant injured by an insurer's unfair conduct, knowingly performed, should be required to demonstrate that the insurer had frequently been guilty of the same type of misconduct involving other victims in the past. Although the language of the statute is not clear, if the premise is accepted that a private party may bring an action for an insurer's violation of subdivision H under the rationale of various precedents, then a single violation, knowingly committed, is sufficient for such an action, close quote. Of course, this is totally against the wording of the statute, but it mattered not to the Supreme Court at the time. The court also concluded the third-party suit may not be brought until the action between the injured party and the insured is concluded, and as a result of the Royal Globe decision, insurers who insured people for their negligence found they were defending two lawsuits. First, the action against the insured, and second, a suit for bad faith claims handling by the injured party. Plaintiffs' lawyers were ebullient. They had two swipes at the insurer. If they succeeded in the tort case without a settlement, then they were able to sue the insurer for bad faith. Rather than defending an insured, the insurer was placed in the unenviable position of defending the insured and ignoring its individual exposure to bad faith tort and punitive damages. Rather than being a part of multiple suits, insurers found it best to settle bodily injury and property damage suits for more than they were worth to avoid having to defend the second suit with the potential for tort and punitive damage judgments. Justice was not served. In my opinion, the justice for the insurer and those insured was destroyed. After Royal Globe, every bodily injury or property damage lawsuit where there was a claim that the insurer refused to try in good faith to make a prompt, fair, and equitable settlement of the personal injury claims was a violation of the insurance code. The plaintiff would then sue the defendant's insurer seeking tort and punitive damages, and as a result, the Supreme Court allowed a person not a party to the contract of insurance to sue an insurer for the failure of the insurer to treat the stranger, the claimant plaintiff, suing its insured with good faith and fair dealing, and not its own insured. The case that dealt with the covenant of good faith and fair dealing were mostly civil, and mostly cases involving the insurer's duty to accept reasonable settlement or duty not to unreasonably withhold payments due under the policy. The caseload in California trial courts almost immediately doubled. Courts were overwhelmed. Many simple cases took as much as 5 years to go to trial. Civil cases were so numerous that they were taken off the calendars because of the need to try criminal cases under the constitutional mandate for a speedy trial. Mandatory settlement conferences were ordered in every case, and judges pressured the parties to settle so that they could clear their calendars to try criminal cases and those that had waited 5 years for a trial. In Royal Globe, a bare majority of the California Supreme Court held that under Section 790.03, subdivision H5 and 14, a private litigant could bring an action to impose civil liability on an insurer for engaging in unfair claim settlement practices. The court ruled that subdivision H5 and 14 imposed on the insurer a duty owed directly to the third-party claimant, separate from the duty owed to the insured with whom the insurer had a contract. To support its holding, the court relied primarily on Section 790.03, which provides that cease and desist orders issued by the insurance commissioner under the Unfair Practices Act shall not relieve or absolve an insurer from any civil liability or criminal penalty under the laws of this state arising out of the methods, acts, or practices found unfair or deceptive. In addition, the Royal Globe Court interpreted the foregoing provisions as conferring on the injured claimant a cause of action arising from a single instance of unfair conduct, so that a plaintiff did not have to prove that the insurer committed the acts prohibited in the statute as a general business practice, despite the fact that Section 790.03 subdivision 8 proscribes, quote, knowingly committing or performing with such frequency as to indicate a general business practice, close quote, the various specified unfair claim settlement practices. The Royal Globe majority held that a single violation knowingly committed is a sufficient basis for such an action. In 1988, in a case called Muradi Shalal v. Fireman's Fund, the California Supreme Court reversed the Royal Globe decision. In reaching its decision, the Supreme Court noted, quote, confirming Justice Richardson's prediction in his Royal Globe dissent, several commentators have observed that the rule in that case promotes multiple litigation because its holding contemplates and indeed encourages 2 lawsuits by the injured claimant. An initial suit against the insured followed by a second suit against the insurer for bad faith and refusal to settle. Thus, one author observed, quote, one result of this decision is that every time a demand is now made to settle a lawsuit, an additional demand is likely to be forthcoming to coerce higher settlements. The demand now carries the threat that unless settlement is immediate, a separate suit will be filed for violation of the Unfair Practices Act. The public ultimately will be affected by the additional drain on judicial resources. Moreover, the public will indeed suffer from escalating costs of insurance coverage, a certain result of inflated settlements and costly litigation. Close subquote, close quote. After the decision became final in 1988, no private action may be brought under Section 790.03 subdivision H unless a final judicial determination of an insurer's liability has been first obtained and Royal Globe was overruled. Muradi Shalal changed the law back to where it was, and since the decision of Muradi Shalal, an insurer acting in bad faith must be and may only be disciplined by the California Department of Insurance, which eventually created the California Fair Claim Settlement Practices Regulations in 1993 to give them the authority. This article was adapted from my book, It's Time to Abolish the Tort of Bad Faith, which is available from Amazon.com as a Kindle book or a paperback. In my opinion, Muradi Shalal stopped one abuse of the so-called tort of bad faith, third-party bad faith. It left alone first-party bad faith, although the argument that the statute provides an administrative remedy for bad faith claims handling and the effect of the California Claims Settlement Practices Regulations in 1993. The Supreme Court did not apply the same reasoning to first-party bad faith because the appeal only dealt with third-party bad faith, and no one has since tried to make the same arguments of Muradi Shalal for first-party cases. The arguments, in my opinion, used in Muradi Shalal apply equally to first-party bad faith cases, and it's time for the California Supreme Court to get it right. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can subscribe to the blog and you'll receive notice of every blog posting, usually 5, sometimes 6 a week, and you'll also gain access to the more than 4,900 blog postings. You can subscribe, and I'd appreciate it if you do, and please tell your friends and colleagues about the blog so that they too can subscribe. And if you're interested in further detail about insurance, insurance claims, insurance fraud, and insurance law, please consider subscribing to my Substack publication. Thank you for your attention.